I call the case of Kimberly Hassel versus UW Milwaukee. This is EID case number CR 2017029886, EEOC case number 26G 2018002330C. I'm Administrative Law Judge James A. Schock. This is a continuation of a hearing commenced in April. Ms. Hassel appears in person pro se. Appearance for the respondent, please.
Jennifer Herzog on behalf of the University of Wisconsin-Milwaukee.
Okay, and let's just start off with the question that Ms. Hassel asked regarding the use of respondent statements. And the issue is you proving that the claims at this hearing are pretextual, not to try to disprove or something the statement. I don't know if that's what to describe. The issue is the combination of things to show that the items are pretextual for discrimination or retaliation. And that's not directly any piece of evidence. Is that, you understand what I'm saying?
You advised me, to make sure I'm understanding, you advised me that we were not going to discuss the adverse actions that were part of the first complaint, and I understand that. You admitted the UWM's position statement for the first complaint into the record as evidence, and so I'm wondering if I'm allowed to ask questions regarding what they have written in the position statement for the first complaint.
Not if it's not relevant for this hearing. Okay, because these things are different, and I'm about to go over that dealing with the situation again. If it is, well, let me just do it in part of what I was going to describe regarding the balancing act that I'm trying to do here regarding evidence. My understanding in dealing with the situation is that this hearing with claims based on sex, opposition, and retaliation for filing the previous complaint was filed on October 13th, 2017, right? And just dealing with the check, and because these dates are important because, among other things, any actions claimed that occurred after October 13th, 2017 are not in the complaint, and we will not, if they are relevant, that's one thing, but as far as the actions themselves, they will not be considered within the scope of the hearing. Okay, and my understanding is that the earlier case was filed on November 28th, 2016, and served on or about December 5th, 2016, and so that presumably that the respondents received notice of it shortly after December 5th, 2016. Is that correct? Are you disputing that, Ms. Hassel?
No, I believe the position statement says the 8th, so that would be accurate, what you stated.
Okay, but right, so that Ms. Herzog, you're agreeing that it's, that the 8th was when you got it?
Yes, approximately.
Okay, so that in dealing with the issue of retaliation, we're looking at before, after December 8th, when it was received. Okay, so, and my understanding is that we have one opposition being occurred on August 28th, 2013. That's the only date that you're claiming you opposed, right, Ms. Hassel?
The first time I communicated to Dean Stojkovic that I believed he engaged in discriminatory pay practices. That was the first time.
Okay, but you in your previous testimony said that that was the only time that you opposed. At least that's what I had down in my notes.
Okay.
And that the only time that you opposed. And
Yes,
so,
okay, sorry.
so, I mean, the thing is in the situation that, and just to note that in general regarding these claims, that there are, and just sort of going over my thinking because there's going to be a lot of rulings that I have to do on this both ways. My understanding is that the case law in the situation is that the commission in dealing with, or first of all, in the circumstances that the respondent, UW Milwaukee, is the only respondent in this case, and so we don't have in this situation, we don't have um, the Department of Motor Vehicles or the entity that was doing the investigation as respondents. And those things aren't disputed, correct?
Well, UWM is the respondent and the UWM IRB is the UWM.
Well, my understanding in the situation that they, in the circumstances that the nature of the complaint, and I will go look at it again, indicates that the complaint talks about the Myers School, that the Myers School is, or that the school is the respondent. And I will go to the Helen Bader School of Social Welfare is the respondent, not the other entity. Is that what, you know, so in my understanding is that and there's two things about the, you know, the respondent is the School of Social Welfare. And and my understanding is that there is not, that the complaint itself does not include a allegation that the bias was, you know, against the investigating entity. And I can go back to, you know, just to note that the, just a second.
May I speak, Your Honor?
Just a second. I'm just trying to look up the, yeah, the Helen Bader School of Social Welfare is what is listed as the respondent in this situation. And in the description, let me just, because that's the initial complaint, I want to check the other one. Yep. And in the language of the first that yeah, the claims are about interference with the combination of that and the nature of the claims and the situation, say that the that other entity is not a party to this action. And I believe that that has been clear what I ruled before. Are you going to say something?
Yes, please. Thank you. When I reviewed the complaint, and this was a while ago, I believe we allege that we allege the involvement of Dean Stojkovic, Dr. Freiberg, or Dr. LaBelle from the Helen Bader School of Social Welfare, and we note other administrators were involved. Melissa Spadanuda from the IRB is an administrator. There were 2 administrators at the initial meeting when the allegations were formally presented to the IRB.
Okay, well, I'm ruling in the situation. I believe it's consistent with my previous ruling that the respondent is the School of Social Welfare. It's not the IRB. I mean IRL, and both because of what's named in the complaint and also the nature of the language in the point 1 that it's talking about interference by the school into the IRL's activities, not bias by them themselves, and it doesn't talk about any end-all decisions. So my understanding is that just going through the IRL is not a respondent; it's the School of Social Welfare. So we first have that. I note that in the circumstances that there are 2 things that regarding the nature of the complaint that require a broad reading of the relevance. And one is the commission has lately stretched the combination of what constitutes a employment action to include actions that could lead to or are involved in employment. And so based on, and particularly a situation I got overruled on, there was a case involving a school training program in the funeral industry, which this guy was complaining we was discriminated against, and that this program or class was arguably leading to employment in the industry. And I ruled that it was not an employment action and covered, and the clerk reversed me and said that it was. We've had a variety of different case law things saying that if it is involved that way. So my understanding is that these issues regarding individual research situations that I have to include or view that those are potentially, given Lurk's interpretation of that, covered as part of sex discrimination, even though that there's an argument that if you look at it directly, that they are not, that her independent consulting relationships themselves are not employment, but they could affect or impact on her future employment with the university. So my understanding is that I have to receive evidence regarding that on the sex claim. And in relation to retaliation claims, I believe the case law is also clear that the issue is not employment relationship or whether it's an employment action or not, but whether it is actions, even if they're not part of the employment relationship, would pose a chilling effect on the exercise of rights under the Act. So that in dealing with the issues that are before me, that, the question is, and I just to note that it is different, the issue regarding whether or not it constitutes an employment action under sex is different than whether it constitutes retaliation for either of these 2 actions. The standard is a different one, and certainly that the what can constitute retaliation is been interpreted quite broadly. So anyway, and just sort of to note that in both on both of those readings, Ms. Herzog, if you disagree with them legally and on the briefing, that you can tell me with the sort of the edge, but the important thing is to realize that the standard for what is a covered act of sex discrimination is different than what could be a retaliatory action. They have a whole different set of case law regarding what constitutes actions under the law. Okay, and just to check, Ms. Herzog, do you dispute that legally that there's a different set of case law regarding coverage under those two kinds of claims?
I don't dispute that.
Okay, so my understanding is then that we have to deal with, after looking at the basic thing, then we are also going back, and I just wanted to go over this because I'm going to go over the exhibits next before we continue the testimony, because I'm just working on trying to get this balance of scope of this hearing down right. My understanding is that we have a series of actions which are claimed under this, and that we have a situation where the actions involved for this case are just within November 28th, 2016 and October 13th, 2017. That's, we're talking about continuation or dealing with the things that nothing after the October of 17 will be considered as a employment action. I mean, it's covered by this case because it can't be. And you understand that, Ms. Hassel?
I do. So the adverse actions are after I filed the first complaint and between when I filed the second complaint.
Yeah, between the filing of first complaint and when you file the second complaint. And my understanding is that the actions are dealing with them. We have the being told the claim that the ILRL was told to investigate and given information or given instructions and somehow influenced by the school. Second thing, we have the letters, I guess, and I'm forgetting whether it's one or two letters, but in the complaint they're referred to separately. The letter to Chief Flynn mandating, that impacting on professional consultation. So we have this letter situation, and with the concerns regarding use of dealing with professional consulting issue, and encouraging to bring their research contract in partnership with the university, and making suggestions about violating rules on research. And then we have a claim of interference with independent consulting relationships, and the claim that the respondent had sent information to the Department of Motor Vehicles to suspend the license. And my understanding is that those are the only claims in the complaint. Is that correct?
If I understood you, I believe so. So the allegations of noncompliance, the investigation of noncompliance, the letter of noncompliance, the letter to MPD Chief Flynn interfering with consulting, the nature of what was said in the letter to Chief Flynn, as well as the impact of it, and then the referral to the Department of Transportation regarding the parking citation.
Okay, so, and that is dealing with the things that since this is a merit hearing, that the issues regarding the remedies issues also are matters that that I need to admit. Okay, so I'm just dealing with going over these things, and also in the matter for you, Ms. Hassel, that when I have the discussions, I have to make decisions based on the information and my understanding of what it's for. And I'm trying to go over this at the beginning in order to, both for myself and for you, to be able to tell me or to relate to how does this relate to something before me rather than something that's not. So part of my reason for this is to for you to when they have discussions, to be able to refer to and have a description again regarding the situation, and so that you can better advocate for why you're wanting to use things. Now the next thing that we have to do, though, is that we have this underlying, okay, this is covered by the law and this is what's in the complaint. But then we also have the impact of the other case. And that I'm being clear that I'm not retrying something about the other case. So my understanding is that means that since no probable cause was found and upheld regarding the claims of sex discrimination, that nothing that can be presented prior to November 26, 2016, relevant to the sex discrimination case, because they viewed that there wasn't anything that even went to go to show probable cause, much less in the merits on the sex discrimination. So I'm not relitigating the question as to whether that there was any evidence of sex discrimination prior to November 28th, 2016. Any description or talking about the sex discrimination will have to be regarding events between the two, because my understanding is that the other case made a finding that was appealed and withheld to show that there was not even probable cause to show sex discrimination. So you understand what I'm saying?
I believe I understand. I just like it on the record that it's currently under review by the Court of Appeals. So I
understand that. I understand that, but in the circumstances that regardless of the situation, that's on that track and not on this. And I also am going to show that nothing prior to November 28, 2016 can be used to show retaliation because of opposition either, because that the claim did involve a claim of opposition that the respondent opposed, that you opposed discrimination in August of 2013, and you made claims that they retaliated against for doing so, which were rejected in that case, and so then I'm not relitigating that either. Okay, so my understanding is that in the claims regarding sex and, in looking at this, I have to go through, in my understanding of the circumstances, to differentiate between which of these things are being addressed in your evidence, because what is relevant or admissible or thing for this case are different regarding each of these claims. And obviously that the previous complaint did not involve retaliation for filing the previous complaint. I mean, that's obvious. And so that when it comes to that filing, the that nothing of that claim was precluded. But one of the things is that the main evidence regarding showing retaliation because of filing the previous complaint is that it changed things involving how you were treated. Now, obviously, you claimed that you were treated badly prior to December 5th, 2016. So if you are not treated any differently as a result, obviously that it is not the filing of the complaint that impacted things. Now, just to check, and the things is that to find out as to what you are claiming was different because of your filing complaint. Are you claiming that you have evidence that you did similar things than what you did prior to them telling to investigate you before the IRL prior to you filing a complaint, and they didn't do anything about it? Are you claiming that?
I don't think I understood the question. I just want to make sure that I'm clear. So I had never had formal allegations made that I had violated human subjects protections. I had never had, prior to that, I'd never been investigated by the IRB. I never received a letter of noncompliance by the IRB. Chief Flynn never sent a letter, never
Okay,
discussed.
let me just dealing with the see, that isn't the, and just to be clear, that's not, it won't be the issue as to whether there were new things. If there aren't circumstances that the respondent is claiming warranted those new things. Now, my understanding is, just to check, is that the respondent continues to dispute any communication with the IRL at all regarding any investigation. Is that correct, Ms. Herzog?
We dispute that the respondent tried to influence how the IRB conducted the investigation or tried to influence its outcome in any way.
But my understanding is you're also, I thought, claiming that you're claiming that you had no role in the instigation of the investigation either. Is that right?
I would say no, I don't think that's quite correct, because an individual from the Helen Bayer School of Social Welfare had to refer the matter to the IRB.
But my understanding is that the person that did was a coworker and not a supervisor, and so that the School of Social Welfare was not responsible for the referral because it was not done by a person who you're responsible for, correct?
Yeah, yes, that's our contention.
Okay.
And I don't agree with that, and they state in their position statement directly.
Well, again, the point is that what I'm trying to do is to figure out what's in the complaint and what's contested. And so that we know what the hearing is about, because I have a bunch of decisions to do in the situation, the matter. And so just dealing with that claim that you have, that there are, regarding the claim of retaliation, I mean, you have 3 sets of things to get to on the investigation claim, ma'am, on this claim. First of all, you have to show that the communication, whatever it was done by School of Social Welfare Management, not a coworker or somebody who they're not responsible for. Second of all, that dealing with the communication was not required, or that there was some judgment that there was something unusual or different about it. And then you need to show that under the same circumstances prior to your having, I mean, regarding that claim, you have 3 different possible explanations that you could try to prove. One, it was different because of your sex, and dealing comparisons regarding whatever they did and who did it. And secondly, it's because somebody knew about your opposition and did it because of your opposition. And third being because they filed the complaint before. But the thing is in the matter is that if the circumstances don't arise prior to in order to show the pretext, you have to show they're reacting differently to a situation than they would before, not that a new circumstances arose that hadn't existed before. So in dealing with the matter, so my understanding is that in dealing with events, because one of the things I'm trying to deal with is that to what extent are, when I'm dealing with events prior to December 5th, 2016, that there's the prime issues are, was it excluded by in relating to 2 of the claims, sex and opposition, was that covered in the other plaint and so barred for that reason? And then the third reason is potentially it could go to show that you were treated differently after you filed your complaint, but that requires that a similar situation arose prior to December 5th, 2016, and the School of Social Welfare responded differently. Follow me?
Yes, sir.
Okay, so my understanding is that in dealing with the, so just to check and dealing with the matter, my, and are you claiming that there were similar issues that did arose prior to December 5th, 2016, that were treated differently?
Yes, sir.
Okay, well, in dealing with the events prior, we talk about things prior to that date. I will look at, and you can, and that since we have essentially 5 different issues to talk about, I'm going to need, and when we deal with issues in that time period, going to find out and try to look for myself whether they seem related to one of these things. And if not, that you're going to have to point out to, which is this for? Is this for your sex or opposed or retaliation of filing complaint matters? And was it excluded by the previous litigation or not? So anyway, I've tried in the matter in this situation to, to frame my understanding, and sort of we went over these things in a in a in a different situation, but then I want um, to go over to, and you had made references to my admitting something, but at least in my notes or the situation regarding your exhibits, I didn't have anything ruled admitted at this point. Are you saying that either of you do, that I had made rulings regarding any complaint exhibits?
I don't recall that anything had been entered into evidence yet.
Okay, so that I'll just sort of deal with, and can you get and just sort of look at this in my list, because I want to go down this, because I'll be checking regarding the stipulations too.
I think, I say this, I do recall that we may have stipulated to some already. Let me find that note.
Well, I need to go over, because somehow, as you see from what I sent you, I don't have, I need to both get it on the record and get it on the form. I'm not sure, one of the things about these continuations is that there are things that have to be picked up for somehow they didn't get it in right.
We
So
have some
I'm
new
just,
ones anyway, so I think it makes sense to go through again.
okay,
But
so I'm sorry?
Yeah, I'm sorry I interrupted you. So just so it's on the record, and so I understand. I just want to make sure I understand. I'm not, I don't have a law degree. I'm not trained. I had submitted evidence, some evidentiary exhibits. You believed I was trying to relitigate, and so you excluded them. And then we had a hearing, and you told me I could not admit anything, any evidence of anything prior to the first complaint. And then I argued for supplemental evidence, and you allowed some things into the record. That's the second file, the supplemental evidence. I
allowed, as far as to, and just to saying, allowed her dealing with it, I was going to look at and rule on it, rather than to say I'm going to go through the stuff that is clearly a thing. So my understanding is that it's at this point that at least I am trying, and certainly that nothing was dealing with it final on the regard, but that the goal at that point was to get a workable group of exhibits from you in order to rule on admission. It's a different thing regarding to marking them and to considering them than it is to admit them. So we're dealing with a second, a second and third stages on these exhibits.
So am I allowed to make arguments for the inclusion of additional relevant evidence that you
No.
told me I could not admit?
No, we're dealing with these exhibits, okay, that we have at this point, not something else.
Okay. So I
All right.
okay.
So dealing with it first in the matter is that that first marked as complaints exhibit number 1 is the UWM policies and procedures. Chapter 2 is a stipulation to, I mean, the issue of stipulation to foundation and is first. Foundation is that it is what it appears to be, and it applies to this case. And I'm assuming that you want all your exhibits that you have to before me admitted. Is that right?
Yes, I would like all the exhibits. Yes.
Okay. All right. So is the respondent willing to stipulate to the foundation admission of complaints 1?
Yes.
Okay, that's received. What about chapter 3?
Yes.
Yeah, I got a bunch of X's to put in, and when I'm done with this, I'll send you a copy of what I have. Again, what about chapter 4?
Yes.
Okay, so I received complaints exhibits 2 and 3. Okay, what about complaints 4, which is chapter 5?
Yes.
Okay, what about complaints 5, which is the code of ethics?
I believe this is the one that I could find online, but that's, yeah, I'll stipulate to that.
Okay. What about the blank scholarly achievements document? That's complaint 6.
Yes, I'll stipulate to that.
Okay.
I-
What about complaints exhibit? No, what?
Well, so what you have as blank, I actually have as a document that lists that discusses remunerative activity. What isn't
No,
is not.
I mean blank. It wasn't blank, being it wasn't filled in by somebody in particular.
Okay.
I mean, it. My understanding is that what I meant by blank is that this was a document that it appeared anyway that individuals were to disclose their achievements, but what you submit me did not involve a particular person doing so. Is that right?
No, what I have that are date stamped 69 through 77 are the documents, policy documents, supplemental policy documents that discuss remunerative activity. They're University of Wisconsin-Milwaukee, Helen Bay.
Right.
Okay.
Okay. The thing is, in the matter, I understood, and let me just, and I'm scrolling down to get there.
I see. I think the blank document is actually the,
C8 and C9.
yeah, it's on 80,
Okay.
on ERD
Well, I just
82.
wanted to check and see whether I'm certainly, the goal is to get it right. So that's the thing. What I had seen, let me just, Okay, I'll remove the blank, and I think it described differently. It seemed like it was a kind of a heading or cover thing like you do with discovery that somebody's particular thing would follow, but um, um, you know, like you put this before you said what it was, what yours were. So I'll just take out the comment in blank. All right, so what about 7, the guidelines for evaluation of faculty personnel?
I'll stipulate to that.
Okay. Okay, what about 8, the summary of academic activities template?
Uh,
And by template, that one dealing with that would be blank then.
that one I would like foundation on the record because I just don't have any familiarity with that document.
Okay. Then, I mean, what trying to do at this point is to get just to note what we what is contested and what not for the matter, because if it's been admitted in the foundation done, then you don't have to have any questioning about it. It's in as evidence, you know, Ms. Hassel. So that's to save time doing that, and also so that we can try to work on these, you know, how to figure out the combination of the broad scope of evidence which these kind of claims called for, but that they are seriously reduced because of the other case. So we have a initial broad scope of potential testimony, and then we have this previous decision which removes a bunch of things from it. So we have, that's kind of a tricky lines to draw. So, okay. What about in dealing with the C9, the procedures and evaluative criteria for reviewing departmental recommendations?
That one, you know, I don't have a problem foundation, but I do see that it's 2021, so I'm likely I want to reserve an objection to relevance since it's after the date of the filing.
Okay, so my understanding is that's foundation, not relevance. And so, so my understanding is that the question in dealing with it is it requires, in order to have actual foundation, that this was in fact in place at the time. You're not disputing that it was appropriate document, but we have a issue regarding whether it is in effect at the time. So what about dealing with a link to the video, C10?
I actually, if you don't mind me saying, the link to it's the actual video. I provided the actual
No,
video.
it's not,
No, it
because
is.
it just,
I provided it in supplemental exhibits, Your Honor.
okay, so you're withdrawing this one then?
No, I'm not. I'm saying it's the video. It's the actual video. You
No,
said,
not that, what complaints exhibit 10 is not the actual video, it's a link to the video.
okay,
So, so it is not the video. It is just the page that has the link on it. So, you know, that's, you know, the video is a different thing, because this is just the page with my understanding is then the page with a link on it would not add any evidentiary value, correct? Are you withdrawing the page link,
I'm not
Or-
withdrawing it. The link, I'm not withdrawing it. The link shows that it's in the public forum, that the video is in the public forum.
Okay, what is the respondent's position regarding C10?
I'm not stipulating to that because it's a document created by Dr. Hassel. She'd have to lay the foundation for how she created it, its relevance.
Okay. And again, and dealing with the, and I am not, when we look at, I think if the video is one of the things, then we can talk about that there. But as far as, let me just get to,
Your Honor, may I say something?
we have just said there's just not an agreement on it, so that let me see what you were going to say. What are you going to say?
Okay, thank you so much. So I understand now that this is the link to the video. It is the exhibit. The supplemental exhibits, I provided the video, and I do not see that you added it to the list of you didn't add it to your list of exhibits. So it should be listed on your list then, because I provided it with the supplemental and you'd given me permission to do so.
Okay, and I am, how and when did you do so? I just,
We had a hearing. You told me which evidence I could admit as supplemental. So I
what, yes,
submitted.
but when did you submit it? I may have said that, again, and it wasn't in the situation that I was dealing with the question of what I'm going to mark or what is a legitimate exhibit list, that I made no ruling on it. And so when did you supply it to the, there is this is the IACP video of Sikovic?
Yes, sir.
Okay, and dealing with the, okay, then I do have it. I got it on April 20th of 2020. Ms. Herzog, did you get that?
I'm sorry, let me just quickly look. I'd probably need to repeat that date.
On that, we got it a situation of April 20th of 2020.
Dr. Hassel, did that also come in an email to me?
Yes, multiple times, because I had problems sending it. The judge's email address wouldn't accept it. And so I actually copied you on the email multiple times. So I actually sent it to you multiple times.
I may just be looking at I'm looking at April 20th.
Yeah, we got it through the our method of doing it, and not
Okay,
if
here.
you did that you would have gotten it sooner. You want me to send it, forward it to you?
I'm just looking at, I've got an email from the 15th with 2 PDFs attached. I have another email from the 15th with a zip file that has a PDF in it. I have another email from the 15th that has 2 PDFs attached to it.
Probably one of those.
So I guess that's what I meant. But it would be a video attachment, correct?
Yeah.
So yeah, I'm seeing the PDFs. I'm not seeing a video.
I sent the video and I explained that it wasn't being delivered, and so that's why the judge gave me the link so that I could upload the documents, and I uploaded the video.
Okay, but did you send me the video or a link to the video?
Video. I sent the video.
Could you tell me what day you sent it? Because I'm just
I'll
not
have to look.
finding it yet.
I mean, it was the same day I sent all the other exhibits. I think if you see the emails, you'll see that I tried to send the video and the documents all at the same time.
Well, so I've got an email that has, again, 2 PDFs. I have an email that has a PDF and a zip file, and the zip file has another PDF in it. An email that has 2 PDFs. So all 3 of those are from the 15th.
I'm searching.
I have it, but I don't see a way to forward it the way I have it.
So I mean, I know I can't, it's not searching right now. I know I tried to provide it. I'm sure in the email and the text I say in all the emails to the judge that I sent the day that I'm trying to send this. So that's why.
If in the matter and the circumstances that you don't have it, and if you could check someday, sometime today, I can find a way to have it forwarded or something is sent to you if you need it, but I do have it. Have you seen it to know I
did provide the link to the video.
no, I'm just concerned in the matter that Ms. Herzog gets it. I'm not disputing that you made the effort. I mean, that isn't the thing. And I have it in the circumstances. And so that notice of the thing is not the issue, but she needs to get it. And when we get to, well, it'll be complaints 37, she needs to know what it is. So I will ask while you're doing so to have somebody send send it to you.
So if it's the same video that's accessible via that link, I can use the link to access it, but I don't see an actual video in my emaal. But
right, it is.
Okay, well, if you would check dealing with it, see if that links works for you. Because I don't want to know whether I need to send you what we have or not.